Hello, this is Sandi Walker with Keller Williams, and it's Wisdom Wednesday. And so today I want to talk to you about paragraph 10 in the contract, which is title evidence. So when we're buying a house in Oklahoma, we want to make sure that we know that the title is free and clear and that it doesn't have defects attached to it. We are an abstract state, and an easy way to explain an abstract is that it is the chain of title from statehood to the current owner. Our current contract states that the seller, at their expense, will bring the abstract current, and the seller is also responsible for the current UCC certificate or Uniform Commercial Code certificate. That's what shows filings by creditors and notifies other creditors about debtor assets used as collateral for a secured transaction. So this is really the way that a title company knows if there are any outstanding liens, mortgages, probates, etc. against the property. The buyer has the option to pay for title insurance or simply have a title attorney's review of the documents. A title opinion is generally completed by attorney and discloses only the defects which are found from a review of the public records. The opinion is a statement of the attorney's professional judgment. Title insurance, however, goes on to insure against other hidden risks which are not discoverable during searches of public records, such as fraud, forgery, and misindexed items, just to name a few. It also covers items that might be missed by the examiner. As insurance, it provides a remedy in the form of a payment and damages related to claims that result from a defect in the title. Given this additional level of protection, title insurance is generally more expensive than just a title opinion. Me personally, I would never buy a property, however, without title insurance. It's just that important. The buyer, at their expense, will have either a mortgage inspection certificate called a MIC or a PIN survey. Buyers purchasing a residential home in a neighborhood will most oftenly choose a MIC. A PIN survey finds the four corners or the four pins of the property. A mortgage inspection report gives the dimensions of the property and tells if there's any encroachments. Now, I used to think, houses don't move. Why am I doing a mortgage inspection survey? Until one day when we had a mortgage inspection survey done on a house, and we found out that the seller only owned the driveway. So there was a mistake made in the record. It was a clerical mistake, and they had done the legal description incorrectly. And when they did that, they removed the house from the property. So ever since that day, I've learned that getting a survey is super important, and it is part of title insurance in the fact that we don't really know what you own unless you do that survey or that MIC. So go ahead and get that paid for. Once we have the title report in, the buyer has 10 days to examine that title and to make any objections. This shouldn't be overlooked. During this time, if there's an encroachment on that property that shows up on the MIC or an easement of some sort, the buyer has the right to know that. So think about a buyer who is buying an acre lot and plans on building a shop in the middle of the property, and there is a 50-foot easement going through that property for natural gas right underneath where he might want to put his shop. At that point, the buyer needs to decide whether they're going to continue with that transaction, or if they're going to put the shop in a different place, or maybe they just don't want to put the shop there. There are lots of things that you have to think about when you're getting that MIG and you see an encroachment or an easement on the property to make sure you feel comfortable with what you're buying. Now, the seller also has a period of time noted in the contract to cure any title requirements. So say maybe there's a lien that's on there that the seller didn't know about, or there's a probate that wasn't done properly or needs to be done. These are all things that could have an effect on clear title, and the seller has a period of time in which he has the option to cure those errors and move forward. If he's not going to make those corrections, then the buyer may cancel the contract and receive their earnest money back. And then, of course, at closing, the abstract is left with the buyer. Most of the time, it's put into storage and safekeeping with the title company and such. But just note that that abstract does pass from the seller to the buyer. As always, if you have questions, please reach out to me.